Tonight we have a particular forum, the Legal Practice Bill Forum, and we've been conducting a number of forums at PPS over the last about a year now. And I'll just show you a couple of these forums that we've had. We've had the Consumer Protection Act sessions. We've had National Health Insurance sessions with our members. We've had a retirement forum session. We even had an e-tolling. We had an e-tolling session with the South African Institute of Chartered Engineers. And tonight's the Legal Practice Bill. And we're going to be having a Professional Woman of the Year forum a little bit later. So we want to engage more and more with our members and deal with issues that we know are very, very important to our members. Some nice pictures of some of the forums that we've had in the last 6 months. And hopefully we'll get the same kind of attendance as the one on the bottom right there, or the one on the top left, but I know people are definitely held up tonight. My job is basically to introduce to you Judge Peet Nienaber, who is chairing our panel tonight. And Judge, you will introduce the panelists, I believe, a little bit later. Judge is a retired judge of the Supreme Court of Appeal. He is also former chairman of the Pretoria Bar, and people in the insurance sector will remember him as our long-term insurance ombud. And he, in fact, headed an inquiry into the consumer credit insurance a while back. Judge, we remember you in intimate detail in relation to that particular inquiry that we had. We have quite a lot of lawyers here tonight, which is not surprising. I don't know what the collective noun for lawyers is. Has anyone got any ideas? Collective nouns for lawyers. Well, sorry? A bunch of lawyers. No, a bunch. Okay. I can do bunch, but I think we can do better. I believe a disputation of lawyers. That's quite good. An eloquence of lawyers. I think we probably get a bit of that tonight. Now, agreed of lawyers. No, definitely that's not appropriate. I quite like a huddle of lawyers, and probably quite relevant, a quarrel of lawyers. But I'm sure we won't be having any of those particular quarrels tonight. And of course, there's no free lunch, when you attend a PPS function. We do have a word from our sponsor, which is me. And for those of you who are members, you can get your statement of benefits at the back of the room, just in case you want to update your current status. You can get your statement of benefits there, and we do have some consultants at the back of the room. So I know that's exactly what you feel like doing late in the evening, but they are there just in case you would like to avail yourself. We also have a lucky draw for a 500 Rand book voucher, and if we get your completed inquiry form a little bit later, as a form of assessment, you hand these into Michelle and Harriet. Michelle and Harriet, where are you? Okay, at the back of the room, and we have a 500 Rand book voucher. But those are the only formalities from me at PPS this evening. Thank you very much for joining us in your own facilities and your own premises. And Judge Nienaber, I'd now like to hand the evening over to you. Thank you very much. Let's welcome Judge Nienaber.
Thank you, Mr. Jackson. As you said, I'm an ex-member of the bench. I'm an ex-ombudsman, and I was also an ex-PPS member. My job is to introduce the members at of the panel. I'm going to start and ask Mr. Jan Stemmett, who is the Law Society of South Africa Co-chairperson, to commence this evening and give us an overview of the Act, because, like many of you, I am certainly here to be informed, and that would be set the scene. Then I shall ask Advocate Paul Hoffman, Director of the Institute of Accountability, to speak, followed by Advocate Ishmael Semenya, Chairman of the General Council of the Bar, very much in the midst of matters at the moment, and also an AFT member. Then we will have Advocate Rusty Magogabe and Dali and Mpofu, who will present something together. They will do a dual thing. Then Busani, President of the Black Lawyers Association, who will then address us. And I'll wrap up with, and we'll wrap up with Jeremy Gauntlett, who told me this morning that he'd lost his voice, and told me a while back that he lost his way. But here he is, so I suppose we must be thankful for that. I'm not going to say anything more because we're pressed for time. So, to start the proceedings.
Thank you, Judge. Good evening, ladies and gentlemen. I'm happy to be here.
Did I mean to leave somebody else? Sorry, I can't hear on the deaf.
All right. Let me tell you a few things that I know about the bill.
Okay.
And I'm sure there's a lot of questions, and we will learn as we go along. The bill that we received on the 17th of May, I got a copy from our parliamentary liaison officer on that day, has the following main features. It envisages a unified governing structure for attorneys and advocates, the election of legal practitioners, as they are collectively to be called, to the Legal Practice Council and to the regional councils. There is no fusion at this stage. The two branches of the profession are to remain as they are. There will be no legal practice society, which is something that is of extreme concern to the attorneys, because we are used to having a law society, and we are not sure how this new dispensation will look after the interests of the legal profession. And in our representations that we are currently drafting for the Portfolio Committee, we are making a very strong call for the establishment of a legal practice society in the draft, in the bill. Incidentally, the deadline for representations to the Portfolio Committee was to have been tomorrow, but the LSSA and the GCB have asked the Portfolio Committee to give us an extension until the end of August, because at our meeting earlier this month we saw that we had a lot of common ground with the GCB, and I'm talking about the GCB and AFT in their collective structure, and we would like to explore those further, and we hope to have some joint submission that we can make by the end of August. So that's the new. We're not sure about the date of the deadline, but in principle we've been told that the extension has been granted, and we will get the new date within the next day or so. Furthermore, the bill provides for reserved work, much as we have now. The same work that we are currently doing as a profession will still be protected. And we will be doing community service, which is not new. We are all doing pro bono service at the moment, and it will be structured in a new bill. There will be no multidisciplinary practices or MDPs at this stage. You may be aware that the Law Commission is doing a study on that, and the Law Reform Commission, and we are awaiting the outcome before that aspect will be legislated. Other features include there's a lot of emphasis on the public interest. Many of the provisions in the bill based on the promotion of public interest. Some powers for the Minister of Justice, and which we're not very happy with, but some of us are. Then the Ombud is a new animal that will come into operation. The Attorneys Fidelity Fund, as we know it, will continue to exist and to protect clients against theft of trust by attorneys. There's a few extra functions and powers that they are destined to get, and we'll see that how that is going to work. Furthermore, there's going to be provision for mandatory continued professional development or continuing legal education. That is a sort of a points system in terms of which you have to do continuing education, continued education before you get your license to practice, renewed each year. So that is something that's well established in some overseas jurisdictions, but we will see that coming into operation here. It will abolish the existing law societies, the attorneys' structures. Existing law societies, as we note, the 4 law societies based on the previous 4 provinces that we had in South Africa. Those are statutory bodies, and then we also have a voluntary association known as the Law Society of South Africa, of which I'm the co-chairperson. And these structures will then disappear into the new bodies. We have seen that there's provision for the staff and the assets and liabilities of the existing law societies to be taken over by the new Legal Practice Council. It also provides that a lot of the detail will still have to be worked out by the Transitional Council. Many aspects have not been finalized, and it's been left for the Transitional Council to deal with. And that, of course, means that the bill will be implemented in stages. First of all, the Transitional Council will come into operation. It will have 18 months to 2 years to finalize its work. It's got a long list of tasks. And then the Minister will have to promulgate the rules and the regulations. And the existing structures, as it stands now, will continue for 3 years after the bill comes into operation. So after the Transitional Council, after those 2 years, the Legal Practice Council will come into operation, and thereafter the existing law societies will be collapsed. The structure, the governing structure, is very important because this is what kept us and the advocates from reaching a compromise as far back as 2002, when Jeremy and I and a lot of other people were in the Budlinde task team, and we negotiated about this, and we couldn't come to an agreement on what the governing structure was, and that caused us to submit 2 separate bills at the time, and led to the impasse which existed until very recently. The structure will look like this. You'll have the Legal Practice Council at the top, which will be the national body that will determine policy and furnish the rules and regulations and codes of conduct. And then you will have regional councils or regional structures and in various regions. Now, the Act is silent on the number and the areas of jurisdiction. What it does say is that the number and the areas of jurisdiction will be determined by the Minister upon recommendation of the Transitional Council. Some people, like the BLA, say that there should be 1 in each province. Other people feel that there could be less than those structures. There will be no accredited voluntary associations, which is a relief to the attorneys. We saw that if you give voluntary associations the power or the authority to regulate their members, it will lead to a fragmentation and different standards and a lot of duplication, and it would be the end of the attorneys' unified profession as we know it. And we were very scared of the AVOs, or accredited voluntary associations. Fortunately, this has now been dropped. The attorneys and advocates are to be governed in a unified structure, as I said. Now, what does the Legal Practice Council consist of? It is 21 members. That's what is currently provided for in Section 7. 10 attorneys to be elected in terms of the rules, which is a vast improvement of some of the earlier drafts, which said that the Minister of Justice would appoint the members of the council upon nomination by various bodies. And now they are going to be elected, and the rules of the election will be developed by the Transitional Council. It will have 6 advocates, also elected in terms of the rules. 1 teacher of law or legal academic, 3 ministerial appointees, which is at this stage a controversial issue. Some people feel that there shouldn't be any ministerial appointees. Other people say you can have 1 or 2, but they must be representative of consumer bodies and not government employees or similar people. People like the BLA, for instance, are comfortable with the 3 ministerial appointees, but there's no agreement even amongst the ranks of the attorneys. There's 1 representative from the Legal Aid South Africa, and another requirement is that these 21 people should be representative of race, gender, people with disabilities, and also the regions within the country. The councillors of the Legal Practice Council will serve up to 2 terms of 3 years each. One of the big issues that we read about in the papers and that's been discussed at length is the issue of government interference or ministerial powers. And the LSSA has made, in its draft representations, complained about the following points. First of all, the 3 appointees on the Legal Practice Council. The fact that the minister can dissolve the Legal Practice Council and replace it with people of his or her own choice. The minister's power to determine the jurisdiction of the regional councils. The regulation that he or she can make in respect of foreign legal practitioners, their qualifications and experience, and in order to allow them to be admitted and to practice in South Africa. And the minister will also be able to permit persons to practice as legal practitioners just by his own, at his own discretion, which is something that's puzzling to us. How can you just allow that? We'll see what the Portfolio Committee does when we start debating these things. What does the GCB say? Now, I've taken the liberty to just summarize things what the GCB has conveyed to us. They say they support parts of the legal practice bill. There should be 2 distinct legal professions, whereas the attorneys speak of the legal profession, they talk about the 2 legal professions. They want to organize themselves in their own bodies to administer their own rules of conduct for their members. In other words, that means that they want to discipline themselves after furnishing their own codes of conduct, etc. They want to administer their own training, very much the same as they're doing now. And they want to employ staff and to regulate the fees charged by their members. That in a nutshell is what they are mooting at this stage. But how do they respond to the structure that I've shown you earlier? What structure do they envisage? The GCB proposal is the following, that you will have the Legal Practice Council at the top, that will deal with policy issues and issues of national concern, and where the attorneys and advocates can deal with issues that concern them as a group. But then you'll have an intermediary body, as I call it, the General Council of the Bar, probably, that will continue to exist. And below that, you'll have your bar councils. At the moment, they've got about 12, I'm told. And they say that in the new structure, these bar councils will still be more or less organized along the areas of jurisdiction of the High Court. And then for the attorneys, they want a separate General Council of Attorneys with separate structures for attorneys in the regions. Now, this is a bit different from what you've seen before, what is in the bill, and we will have to see what model is ultimately going to apply. The closest the attorneys profession have come to this type of arrangement is a proposal that was tabled last year as an alternative proposal from the LSSA, where you still have your Legal Practice Council at the top, and then in the regions you'll have your separate structures for attorneys and advocates. And you will notice there's no intermediary bodies that the GCB is advocating. So that's the closest we could get to those structures. We still need to negotiate a lot of things, and we may be able to close the gap, but that remains to be seen. Finally, there's the website where you can keep track of progress. It's kept well up to date by the staff of the LSSA, and all the representations made on the bill from our side, as well as various other relevant documents, are accessible there. So if you want to have a look, it's a very good site to go and check what's going on. Also, if you need to send in your comments, you can send it to the CEO, Mr. Nick Swart, and there's his email address, and if you really have to, there's my email address as well. Thank you very much to the Judge.
Thank you, Mr. Stemmett. I'll then ask Advocate Paul Hoffman to say something. I should have mentioned that the speakers will be reduced or confined to maximum 20 minutes, and there will then be an opportunity for all of you, if you'd like to engage with the members of the panel, to do so. We'll see how we are set for time as we go on.
There you go. Thanks. Thank you. Thanks, Judge, and thank you, Mike, for the opportunity. I've been a member of PPS since 1976. This is the first time I've been invited to the Holy of Holies, and very pleased to see that my money has been so well spent. I'm sure this is a sort of advance on my inheritance from my membership. I'd like to find out, just for the purpose of working out who I'm speaking to, how many attorneys there are in the room, and how many advocates, and how many judges. One only. Oh, it says it all. Others, how many journalists? Good to see you, Mr. Gleeson. Bill? Anybody else who's prepared to put their hand up at this stage? I've covered the waterfront. Oh well, at least I know who I'm speaking to now. I'm a retired member of the Cape Bar. It's always a pleasure for me to return to the city of my birth, if not for any other reason than to enjoy the good weather and meet up with the sociable people. Now, one of the complaints of the New South Africa is that the people in Cape Town are racist. Well, I have to tell you that I emigrated from Joburg to Cape Town in 1975. I packed up my Datsun 1600 SS. There wasn't an orange on the aerial, Gerard. And I found the same problem. It's not that they are racist, they're just unfriendly. I thought, as the only non-practitioner on this panel, that I should, rather than concentrate on the game of pick-up sticks that Jan has been playing with you, I should concentrate on some of the broader issues and perhaps a bit of historical perspective on what we are dealing with here tonight. Obviously, we're all the product of our own history, and I was a pupil member of the Cape Bar in 1980 when the National Bar exam was introduced for the first time. And the then chairman of the bar, Pat Tebbett, gave me a chore to do while I was doing pupiling. That was Pat Tebbett's ghost, but he's still alive. The chore was to take a petition around to all the members of the bar and inveigle them into signing it. The petition was to the Minister of Justice, and it was a request that he withdraw the Intermediate Courts Bill. Now, the Intermediate Courts Bill has been long forgotten by, I'm sure, just about everybody in the room, including those of you who weren't born in 1980. And the idea of the intermediate courts was really to pump up the status of magistrates with a view to making the regional magistracy a source for the Supreme Court bench. And the Cape Bar, with two exceptions, both of whom left practice to work for state-owned enterprises shortly after I asked them to sign the petition, the Cape Bar, to a man and to a woman, were not prepared to go along with this idea. And like so many other apartheid-era ideas that were aimed at undermining the independence of the legal professions, the Intermediate Courts Bill was stillborn, and the rule of law, such as it was in those days, was not assailed in that way. Now, today, we have a constitutional democracy under the rule of law, a completely different setup. No longer can Parliament do as it pleases. Those in Parliament and those in the executive, as everybody except the journalist knows, is constrained by Section 2 of the Constitution and can only do that which is consistent with the Constitution. And I think one of the big problems about this bill is that it is inconsistent with the rule of law. So it falls down at the very first hurdle in the very first section of the Constitution. Because the rule of law demands that there be an independent legal profession from which an independent judiciary can be drawn when the Judicial Service Commission does its business of finding fit and proper, suitably qualified persons with due consideration to race and gender to fill the important positions on our bench. Now, how did we get to this point when, having so recently endorsed the idea of constitutionalism, which is certainly consistent with the idea of an independent judiciary and an independent legal profession or professions, depending on which side of the great divide between the sidebar and the bar you sit. How did we get to this point so quickly? And I looked around in my long and hard research for tonight to find a pithy statement of how this came about. And I'm not going to go back to 1917, and I'm not going to give you a short course in a Marxist dialectic. I'm not even going to discuss the National Democratic Revolution, because I'm sure that you will all fall asleep or become exceedingly bored and irritable if I were to do so. Now, instead, I looked, because this is a bill that has been deferred for many, many years, its gestation period exceeds that of an elephant by the power of 5. I looked instead in the introduction to the book written by Mark Gefisser about the life and times of Thabo Mbeki, written before Polokwane. And I referred in particular to page 41 of his introduction. This is what he said on that occasion. Mbeki was deeply distressed by the possibility of being succeeded by Zuma, a strategy to avoid prosecution, he thought. Mbeki allegedly worried that Zuma and his backers had no respect for the rule of law and would be unaccountable to the constitutional dispensation the ANC had put in place if they came to power. I don't need to read more than that. That was written before Polokwane. The head of policy in the post-Polokwane ANC is a man called Jeff Radebe, who also happens to be the sponsor of this bill. And For your edification and delight, and also so that you can send a large check to the Institute for Accountability, there is on every seat or in every pack in this room a short summary of the difference between the constitutional way of doing things and the way that is dictated by the National Democratic Revolution. I'm not going to spend time on it. I'm sure that you are all familiar with it. Some of you are delighted by it, and you are entitled to be delighted by it. Others of you are horrified by it, and you are all entitled to your opinions of the National Democratic Revolution. I'm mentioning it in the context of tonight's discussion because it is what motivates the bill. In a nutshell, the idea is to gain for the party hegemonic control of all of the levers of power. That's probably Jeff Gadebi. Tell him I'm busy. An abandoned cell phone. We better call child welfare. The difficulty with this bill is that it is a living manifestation of the striving of the National Democratic Revolution to obtain hegemonic control of all the levers of power in society. It is a train smash for the public. It is bad for the legal profession, and it is worse for an independent and an impartial judiciary. I'm also concerned about the unintended consequences of this bill. If the intended consequence is that a system which has been built up over hundreds of years, and yes, does have relics of our colonial past attached to it, you will see that advocates get dressed in fancy dress, looking like Batman when they go to court. You will see that attorneys in big cities arrange themselves into large practices, whereas the boereverneekers on the platteland are quite happy to operate singly or in pairs, and that there is a wide diversity in the way that law is practiced, whether as specialist at the bar or as general practitioner, as a member of the attorney's profession. The unintended consequence that I foresee, and it is not a bright picture, it's a dusty picture which may or may not eventuate, is that this unity that is being striven for, why I don't know, because it seems to me that the division is a good one, will lead to a situation in which all of the best talent at the bar's talent is really in advising and litigating, appearing in court, preparing pleadings. They don't do much else, whereas the attorneys are general practitioners. The bar's best talent will be swallowed up by the big corporate firms, and the small practices, the run-of-the-mill attorneys' practices, will suffer through not being able to tap into the talent that is available at our bars. And this will not be good for the public, because most attorneys' firms cannot afford the overhead involved in employing or having on board full-time an advocate, but they can, for a specific case, for a specific client, temporarily, as a sort of piecework arrangement, have access to the best brains at the bar and do the best they can for their clients. This is a system that works, and there have been attempts in the past to suggest fusion. This halfway house of unity, or I'm not even quite sure what the idea is of unified control, seems to me to be a first step on a slippery slope. So Let me tell you another story, now that I've told you the story of the Intermediate Courts Bill of 1980. Shortly before that, there was a very prominent silk at the Cape Bar who got into an argument with the bar as to whether or not he was acting in a conflict of interest situation. His name was Sam Aaron. Those of you who read your law reports before you go to bed at night can look up Benjamin versus Gurevitz. That was the case in which it happened. And Sam Aaron said, well, if that's the way you feel about this, I'm out of here. And he went and he signed articles with a firm called Sonnenberg, Hoffman and Golombek, which today is called ENS. And he got, at a time when article clerks were being paid about 200 Rand, 300 Rand a month, he got 6,000 Rand a month to be an article clerk for Sonnenberg, Hoffman and Golombek. So he was an article clerk on steroids. So why am I telling you this? Trouble is that Sam Aaron had a wide and varied practice and was briefed by many attorneys in the northern suburbs, across the Boerewors curtain, southern suburbs, north of the Lentil curtain, in the Platteland, all over the show. People, when they had a big problem, went to see Sam Aaron. When Sam Aaron became an article clerk at Sonnenberg, Hoffman and Golombek, the clients had to be told by their various attorneys that if they wanted the benefit of Sam Aaron's advice, they had to become clients of Sonnenberg, Hoffman and Golombek. So when a Johnny-come-lately from Kimberley called Louis van Sale arrived to punt the idea of a fusion of the profession in the Cape, his entreaties fell on deaf ears because the attorneys in the area had experienced at first hand what happens when useful advocates get snapped up by big firms. I'm concerned that something similar, maybe not as dramatic as that, may be the problem. But I think I've just about overstayed my welcome. So before I say good night and get ready to go and check how much I'm worth in the back of the room, I just want to draw the attention of those of you who are seriously worried about this to a definition of the rule of law that makes it very clear that the independence of legal practitioners is vital to the upholding of the rule of law. And as we all know, our politicians are sworn to uphold the Constitution, which embraces the supremacy of the rule of law. I refer, of course, to the World Justice Project. And if you want to Google it, all you have to do is run those three words together, worldjusticeproject.org, definition of the rule of law. These are the people internationally who have devised the rule of law index. They produce it on a thing called a spider graph, which, if the spider web is tiny in the middle of the circle, you're talking Somalia. And if the spider graph is huge on the perimeter of the circle, you're talking Sweden, Norway. And South Africa, I'm pleased to say, falls somewhere between the extremes. Doesn't have such good marks on access to justice. And South Africa has been a guinea pig from day one in the compilation of the Rule of Law Index. On that website, you will find a comprehensive definition of the rule of law, which stresses the importance of the independence of legal practitioners. My concern is that this bill will be destructive of the independence of legal practitioners. And so without playing pick-up sticks and looking at all of the structures and all of the rest of it, I say, as a matter of the scope and direction that this bill is taking, it is an onding, it is unconstitutional, it will not pass constitutional muster if it is ever placed before the Constitutional Court for scrutiny, and it ought to be taken back to the drawing board for another long, hard look at why something that ain't broke needs to be fixed. Thank you.
Judge, good evening. Colleagues, am I sufficiently audible? I thought it best if I started by sharing with you the events of Saturday past, where the GCB sat on its 67th annual general meeting. But so that I don't detain us too long, let me just cite some of the issues that were raised there and how the GCB looks at the total picture. There is a recordal in the press release which reads as follows. It is also important to record that at an annual general meeting, a resolution was adopted in terms of which the advocates profession expressed its support for parts of the bill in principle. The GCB noted the introduction of the LPB, which inter alia seeks legitimately to address the following issues. The fact that the practice of law is regulated by different laws which apply in different parts of the national territory and as a result is fragmented. The fact that access to affordable legal services is not a reality for most South Africans. The fact that the advocates and the attorneys' professions are not representative of the demographics of South Africa. The fact that access to legal services is limited. Somewhere in the body of that says the resolution of the GCB. For this reason, the GCB has resolved to work with government and the legislature, the Law Society of South Africa, the BLA and NADEL, and all other stakeholders in order to address the legitimate concerns which these stakeholders have, and to this end will engage in frank and robust discussion with the legislative and executive arms of government based on the following principles. One, that the advocate should have the right to freedom of association, in particular, the right to organize themselves in their own bodies. Two, that the advocate's profession should be recognized as a distinct profession within the wider realm of legal practice, and to this end should be able to administer a system of pupillage or practical training required for admission to the profession, and in doing so promote access to the profession by historically disadvantaged individuals. Formulate and administer a set of rules of conduct for its members and a disciplinary system for the infraction thereof. Employ personnel and own assets for the administration of the profession. Ensure that the fees charged by its members are reasonable. And the GCB considers the retention of the above principles as being in accordance with the aims and objectives of the bill. Can I now try and paint a different picture to what is popularly sponsored? I think we can accept as a premise, and this is my reading of the environment, we can accept as a premise that the Constitution correctly points out to the fact that we are a legal system that obeys the rule of law. That's one of the foundational values that the Constitution articulates. I'll be surprised if there is anybody who will contend that there is a piece of legislation in this country which will pass constitutional muster at the same time that it abrogates the rule of law. I can't fathom that happening. Secondly, a casual reading of the Constitution also will tell us that the profession of advocates and those of attorneys is recognized as distinct entities that are not going to be abolished by mere passage of legislation on the regulation of the profession. That too will have to be in line and consistent with the dictates of the rule of law. The rights of professionals to practice as they do is also protected under the Constitution. I'll be surprised again if it is going to be disturbed purely because some agenda lies somewhere else in some closet of a particular political organization. I doubt it very much. But I also have discovered that perhaps one of the difficulties associated with the 8-year gestation that has made the passage of the regulation of the profession difficult has been matters of public utterances at times which are unfortunate and retaliatory comments which are also equally unfortunate. And from where I see it, I always make the proposition that you are not going to make lions carnivores because you call them cattle. And neither are you going to make cattle carnivores, rather, because you call them another name. Now, I'm not a fellow traveler with the views that are expressed by Mr. Hoffman. But what is important is not because I differ with him. I want to understand why it is that he holds a view different from the one that I do. And I want to avoid the sound bites, because to call a bill a train smash, to call it a living manifestation of hegemonic control of power, to say that the public will be swallowed, it is the worst thing for the independence of the profession and independent judiciary, may very well be descriptions that are accurate. But I think before we describe them as accurate or not accurate, it is critically important that we understand the reasons that inform those conclusions. And that is what I don't find often in the public debate on this issue. Now, you can accept that I am not one to suggest to anybody that politicians are to be trusted, or that the legal profession should be less than vigilant in protecting its independence. But at the same time, I think it is important. It is important that our criticism, if they are valid, they are well articulated, so that the vainness of opposition must reveal itself for what it is if it lacks substance as an answer to the charge. And to my mind, this debate will find a lot of area of improvement if what we deal with is the substance of the charge. Against that background, I want to make an observation that nobody who is a lawyer will contest the fact that the only entity in a constitutional democracy for which the Constitution reposes the responsibility to protect public interest is not the judiciary, it is not the legislature, it is the executive. The policy-making competence and power resides with them. The question of access to roads, the question of access to justice, the question of access to public welfare are all matters that are of public interest over which government has a legitimate right to play. But they too should know that there are hurdles in doing anything that goes outside to their constitutional power in the province of policy making. I think that's the first observation I'm prepared to make. But I'm also prepared to make the next observation. It will be foolhardy of any government, and many governments have transgressed that province. It will be foolhardy of government to try and seek to govern the profession. I don't even think they have the money for it. I don't see how government is going to run the Johannesburg Library. I don't even know whether they are able and competent to appoint a librarian for that matter. So the governance of the profession will remain and must remain the business of the profession. Regulation to protect public interest is a different matter. And I cannot see this profession sitting down to see a day in which there will be an erosion into the institutional independence of the profession. No, there will be threats to the independence of the judiciary, which ultimately is entrenched under our Constitution. What am I inviting? I'm inviting a measured approach to the problem, a reasoned approach to the issues, and a corrective engagement in relation to matters where there are diverse opinions and differences. I think that will help the profession achieve its professional independence it is entitled to under the Constitution. It will protect its legitimate territory where it plays in the provision of legal services, and we will avoid the disaster that sometimes is being forecast. You can also accept that the bill will not be law in the form that it stands. There will have to be proper engagement with government, perhaps with a view to correct than to mock. That is my contribution.
The two of you are going to do it together. You want to go first? Well, Advocate Rusty Magogabe from the Advocates for Transformation will start a duel with Advocate Dali Mpofu. Both walk along the same line. Have I got it right? Excellent. Thank you very much.
Thank you, Mr. Chair, colleagues, comrades, ladies and gentlemen. First of all, I would like to point out that we are here to represent the position of the Advocates for Transformation on the Legal Practice Bill. Simply put, we are called AFT, but as a matter of fact, we stand for transformation of the legal profession. I would like to mention that, in fact, the person who was supposed to speak tonight was our national chair, Advocate Dumisa Zebenza. However, as he is involved in other engagements, he mandated us, we always there, not to be deployed, but carry on the task of advocate transformation. And me and my comrade here, Dali Mpofu, want to make a dual presentation. I think it's going to be one of the best duet lawyers has presented in this country. With that introduction, I will speak on the formal position articulated by the AFT regarding the legal practice bill. This is mirrored in the resolution taken by the national body of AFT at its annual general meeting in Umtata last month. We need to mention that we in the Advocates for Transformation do not see the bill as a first step to a slippery road. On the contrary, we see it as a first step to transforming the legal profession. We do not think that this bill is a product of a party or purposes of gaining or achieving hegemonic power of all levels of government or power, or as a living manifestation to maintain such hegemonic power. Our approach is one where we are trying to be constructive and obviously to support whatever endeavors there are with regard to transforming the legal profession. It is against background, and Dali will elaborate on it later on, that this resolution was taken. And this resolution reads thus: a resolution of advocates for transformation as adopted by the AFT held in Tata on 24 June 2012. Advocates for transformation, AFT, noting that, one, I'm not technical, I'm a lawyer, no, so I don't know what these problems are. The mic. SABC to the rest. Thanks, Dali. Noting that, one, the latest draft of the legal practice bill acknowledges the right of advocates to practice their profession. Two, the transformation objective set out in the bill, particularly its preamble. Three, the crying need for access to justice and legal services for the majority of South Africans, more particularly the historically disadvantaged communities. 4, the transitional mechanisms and negotiations provided for in the bill. 5, the bill is intended, amongst others, to provide a legislative framework for the transformation and restructuring of the legal profession, to ensure that the legal services are affordable to and within the reach of the vast majority of citizens, to remove barriers to entry into the legal profession, and to strengthen the independence of the profession. Hereby resolves, 1, to support the legal practice bill in principle. 2, to engage in discussions with all major stakeholders, including the Black Lawyers Association, NADEL, which stands for National Association of Democratic Lawyers, the LSSA, which Mr. Stemmett was speaking about earlier on, as well as non-AFT members of the GCB, to debate the issues raised in the bill, and in particular to address the legitimate concerns of our colleagues in the profession. 3, to engage in robust and frank discussions with the legislature and the executive arms of the democratic government in addressing any remaining concerns of our constituencies. 4, to ensure that in its final form, the envisaged Legal Practice Act will indeed address the problems identified in the preamble of the bill, namely that, 1, the legal profession is regulated by different laws which apply in different parts of the national territory, and as a result, thereof, is fragmented and divided. 2, access to affordable legal services is not a reality for most South Africans, which is obviously, it's truism. There's no one who can obviously dispute that. 3, that the legal profession is not representative of the demographics of South Africa. 4, that entry into the legal profession is, in some respects, dependent on compliance with outdated, unnecessary, and overly restrictive prescripts. 5, access to legal services is limited. The next, that we should take all necessary steps to ensure the widest possible public support and buy-in by all important stakeholders, including our members, the broader profession, and the majority of South Africans, which is not limited to lawyers, but that, in fact, even laypersons should be allowed to make an input in trying to address whatever concerns there are in the profession, because after all, everything said and done, the consumer of the legal services broadly are, the public in general, and that, in fact, they should also be allowed to make an input in fashioning or shaping the legal practice bill. With that, I thought I'll go on with my sonorous song, but at this stage, I think I will pause and allow my dual partner, Dali Mpofu, to elaborate, expound on, and speak to this resolution as to what, in essence, informed this resolution. Thank you.
Thank you, Rusty. Good evening, Judge and panel members and colleagues. I'll try to be brief, which is not something I'm famous for. I just wanted to put this matter into perspective. I think the problem with some of the hyperbolic statements that get made about this bill is that most of them are not based actually on what the bill says, and they're based on all sorts of scare tactics that get postulated, such as the National Democratic Revolution, whatever that is. But if you look at the bill itself here, we as the AFT, the fact that we support it in principle should come as no surprise, because how would an organization like ours that is called Advocates for Transformation oppose a bill whose first line, if you look at the actual text and not the urban legends, the first line says, bill to provide a legislative framework for the transformation and restructuring of the legal profession in line with the constitutional imperatives. I mean, where they say the purpose of the Act, Section 3. The purpose of this Act is to provide a legislative framework for the transformation and restructuring of the legal profession that embraces the values underpinning the Constitution. Now, it would be absurd for us to oppose such a thing. And then, of course, the preamble that Rusty read out. Without repeating, I just want to emphasize that the preamble to the bill simply says, and if anybody differs with any one of these, I would like to put my money that they don't have the interests of South Africans at heart. The preamble identifies the following problems. The profession is regulated by different laws applying in different parts of the territory and is fragmented. Fact. It says access to affordable legal services is not a reality for most South Africans. Fact. It says the legal profession is not representative of the demographics of South Africa. Fact. And it says entry into the legal profession is in some respects dependent on compliance with outdated, unnecessary and overly restrictive prescripts. Fact. And it says the access to legal services is limited. Fact. So you'll struggle to find anyone who will differ with those problem statements. The question is, does this bill, as it stands now, talk to that preambular statement that we all must agree with? And there's no simple answer to that question. What our standpoint is as AFT is that we're going to spend the next 6 months, the 2 years that is defined in the Act for the transitional period, to ensure one thing, that the final bill speaks to these ideals. It's as simple as that. And that's what we want to do, that's what we want to invite everybody to do, to ensure that insofar as it may well be that the current bill actually does not or offends some of those lofty statements, well, then here we are. We have a forum, we have a parliament, we have a constitutional court, we have a transitional council, and all sorts of mechanisms to ensure that that alignment is achieved. And by the way, just the one issue that seems to be worrying everybody, which is the representation of the minister in the 21-person body. I think Jan has put it correctly. There are various views about this. I, for example, and now I'm just expressing a personal view, I'm of the view that if, for example, just to illustrate what this alignment issue I'm talking about, if the bill really is about accessibility to justice for the ordinary people, then why do we only have one representative of Legal Aid South Africa? And that's the kind of engagement that we should all have. We should say, for example, well, Mr. Minister, why must you have 3 representatives and Legal Aid have 1? Shouldn't it be maybe 2? There's an article by Kamel Ricard in today's Star, which raises another important issue about paralegals. Maybe they too should be represented in the body, if indeed it is about access to justice. And I think that's the kind of engagement we should be having, and the kind of proposal we should be putting on the table to make sure that that alignment is achieved. But to suggest that per se, the mere fact of having a ministerial representative in a body suggests control and hegemonic control and all these big things is in my view, not substantiated by fact and experience. I've made this example before. I was once appointed as a ministerial representative by Adv Ishmael to the University Council of the University of Johannesburg, or RAU actually as it was then, to oversee the transformation of that institution to the present-day University of Johannesburg. And I can tell you now, not once was I ever given some surreptitious instructions by the minister to go and take over that institution for Marxist reasons. All that happened, actually, in real fact, is that whenever I had to see the minister as his representative, most of the time it was to tell him not to do something because the university, it would harm the university's interest for this and that and the other. All I'm saying is that it doesn't necessarily follow that if you have a ministerial representative, whether it's 1 or 2 or 3, is a matter for debate, that automatically translates into all these scary things. Final point I want to make is that the bill, we've had a lot here about the rule of law. And that's why I say, if you just read this thing, some of these things are answered. Section 4 of the Legal Practice Bill talks about the objects of the council. And there are 13 of them, so I'll only read 3 just to assist you. The A, it says 5A, to facilitate the realization of the goal of a transformed and restructured legal profession that is unified, accountable, efficient, and independent. E says to preserve and uphold the independence of the legal profession. K says to uphold and advance, wait for this, the rule of law, the administration of justice, and the Constitution of the Republic. I'll stop right there. Thank you very much.
I'll now call on Busani Mabunda, President of the Black Lawyers Association.
Am I audible? When an invitation was extended to the BLA to participate on this debate, I will need an indication with respect to time because sometimes I can talk. We were asked on whether we have got something like what Mr. Stemmett had to flag and make it look nice there. The ultimate answer to that question was that no, there is no need. And indeed so, that conviction was correct, having had an opportunity of listening to the speakers who spoke before me. I should, from the outset, point out that the views which I will be expressing have been shared and assented to by the National Association of Democratic Lawyers, NADEL. In other words, they are in concurrence with what is going to be said. Quod principi placuit legis habet vigorem. Whatever pleases the master has the force of law. The Queen can do no wrong. The genesis and evolution of the rule of law to what it is understood to be today emanates, amongst others, from the outlined principles. You will recall that at some stage, some 22 years back or so, Latin and Afrikaans were abolished, and they were said to be compulsory courses for you to become a lawyer. In other words, these two were conditio sine qua non to practice, either as an advocate or an attorney. We know how many victims were there, and some of our colleagues were only able to get admitted upon the abolition of Latin and Afrikaans, respectively. The model, the current model, of which the laws or the regulation of the profession in this country is based on, it's more of an English orientation. I must point out that times have moved, even in England and Wales. They are not clinging to the current system in South Africa as it presents itself today. And that is a fact. Having moved from this Roman maxim, the Queen can do no wrong, and parliamentary sovereignty, as well as its content, we embraced the constitutional democracy. 18 years down the line, 18 years down the line, nearly 2 decades, we are still debating on whether or not we do need a new legal practice act which aligns itself with the ethos and object as enunciated in the Constitution 18 years down the line. That's extremely shameful, to say the least. Let us look at various professional areas. They have transformed. They do have new acts aligning themselves with the new constitutional dispensation and the object as outlined in the Constitution. And guess who was central in terms of drafting and advising on how it should be? the lawyers, we who are sitting here today, but we are lamenting and griping about the contents of the bill. What should the approach be? I think advocates for transformation have succinctly and aptly captured the essence of the bill and what it espouses to be its object. What is the harm in the bill coming yes to the object as set out? And now we start zooming into the language and content with the view of assessing whether or not it deals with the object as it says it will. Wouldn't that be the acceptable duty of the lawyer? That is what, and we must remove the fear, because the fear is taking us backwards. And we cannot continue to live in antiquities and allow what we call the new constitutional dispensation to go into the third decade without us aligning ourselves with those provisions. Now, where are we? The bill has been put in Parliament. There is an invitation to members of our society comprising of stakeholders within the profession. Advocates for Transformation, Black Lawyers Association, NADEL, Law Society of South Africa, the General Council of the Bar, and these provisions are not limited to those who have mentioned. Everyone present here today, in his or her own right, as an individual, is entitled to make submissions and say, we see limitations on this bill because of this and that and that and that. And in order to align itself with the imperatives or objects as it sets out, this is how we believe that this object can be achieved. We must be candid to ourselves on whether or not we are committed to the cause of democracy in this country. We must ask ourselves whether, when we said we respect, understand, and embrace the new dispensation as it manifests itself, we were bluffing. If we were bluffing, this will be met out by the form of resistance which has permeated itself and manifested itself through the electronic and print media, where certain views have been expressed and purported to be the alpha and omega representing the views of the legal profession in this country, which is patently wrong. We need an introspection. We must agree that this is shameful. Let me talk a little bit about the language which captured space within the media, in particular, as stated by the next speaker, Mr. or rather Advocate Jeremy Gauntlett SC, saying, I quote, "The legal practice bill is the biggest single threat to an independent legal profession and so to courts in South Africa's legal history." This cannot be correct, and I invite legal practitioners not to accept this. I don't know, I don't have better way, of expressing myself for us to distance ourselves from that kind of language. Because it does not actually represent or capture the essence of what is expected of us. If anything, there is an indictment on us as lawyers. The other thing, well, credit to him, of course, he did point that he was speaking in his personal capacity. So he is talking as an individual, just like you sitting there expressing your view. Now, we have got institutions which represent stakeholders, and we have engaged in serious and painstaking exercise in an endeavor to see the realization of what is needed in this country. 14 years or so, having the bill, with some people even saying that the bill will not see the light of day in their lifetime. Now is the time. We must clear the dust and face the bill. We are lawyers, for good's sake. Why can't we embrace our country? Why can't we challenge those facets of the bill which seems to show that the minister is somewhat usurping what we believe to be the powers of the profession, and engage constructively, clause by clause, and say, this is how we believe you could deal with the issue. I alluded on processes. How many minutes do I have? 2 minutes. I have alluded on the processes which are being followed, and then we are going to engage in Parliament, and after engaging, those who will make the cut will be invited to come and make submissions, and there is a general expectation of not acting irrationally by the portfolio committee. And because of the checks and balances, there are ramifications which flow from them not acting in the spirit. And it is only at that stage, when there has been an assent and then the signing in making it an act, that we can talk about the constitutionality or non-constitutionality of a bill, of the bill, or else of the act at that particular stage. Right now is the time for invitation and hammer where you feel that, and then this is constitutionally wanting. You are being given an opportunity. I am afraid I just don't have time. If I had time, I would be dealing with the views which were expressed by Hoffman SC, of which I do not associate with, and then they are dangerous, and then they are taking us back as a profession. Thank you very much.
Well, Advocate Gauntlett has been mentioned, and he now has an opportunity of saying so. He is himself, of course, a past chairman of the General Council of the Bar and deeply involved in these matters. Advocate Gauntlett.
Thank you, Mr. Chairman. I have a few things to apologize for. First is vicariously on behalf of the person who stole the sign at the end of the road, which is related to the second, that many would think it's entirely appropriate that a lawyer speaks to you dressed entirely in wool. But I do apologize for that, and no disrespect to my colleagues. It is a consequence of the fact that until early this afternoon, I was 25 meters above sea level, not in Cape Town, but crawling around a mine shaft closer to you. So for those reasons, I'm sorry, and as I say, I mean no disrespect by appearing before you looking like a rather elderly version of David Beckham. We're long past any time limit which has been set for the speakers, and I shall try to be very brief and to pick up what seem to be the main threads. We've reached that stage where once was memorably said by the last Attorney General before the United Kingdom Parliament. We've reached that stage of a discussion where everything has been said on a subject that could possibly be said, but not yet by everybody. What I would like to do is explain and say very simply why it is that I do believe this bill is such a threat in the terms which I wrote about and which you've heard repeated to you. I can't repeat what I wrote. Many would have read it, and you would agree or not agree in some of the aspects, but these are the fundamentals. I will mention them in an order which facilitates brevity. Each of these, or may I just say this first one, is entirely uncontroverted, that in all the time that this bill has been under discussion, it has not been costed. We have no idea what the implementation of the system will take, what cost will be borne, and of course who will bear it. This has implications for what we hear about much at a rhetorical level, namely access to the profession, but it can only bear down heavily on many young practitioners, many struggling law firms. It's a nuts and bolts point, but it's so fundamental, because I'd understood it a parliamentary commitment at the time when I was chairman of the GCB, that no measure would come before Parliament which was not costed. But it has not happened. The second objection is related to it. There is no clear idea how it will happen. This was usefully illustrated by aspects raised by Jan Stemmett and by Ishmael Semenya. We don't know how it is thought that a system which is currently rolled out from Simonstown to Musina, largely through the services of practitioners who give up their time, their hours unpaid, to attend to training, to discipline and the like, how it will work through these regional councils, which we see depicted, and I've seen this for 12 years now, depicted in the kind of graphical depiction that Jan Stemmett so helpfully put up for us. There is a void at the center of it. If the assumption is that the assets will be taken, the staff will be taken, the autonomy will very substantially be taken, but that members will continue in the ethos of the past to give up their time, it's a very dangerous and questionable assumption. It's certainly one which has not been properly explored. And in this regard, I should say that we don't approach this topic, I believe any of us who have been involved in it, in a destructive spirit. In the period of time when I was involved, we sent through 6 drafts of a bill to the minister. I don't know if this was known by the last speaker. And as regards the Law Society, Jan Stemmett will confirm umpteen drafts which it has sent through. And both Jan and I and many others have lost part of our youth at what is now Oliver Tambo Airport in endless meetings seeking to find common ground and to find the ministerial team as it changed. The third objection is that there has been faith broken. I itemized, detailed in the piece I wrote the fact that on a specified date there was a specified meeting at which it was agreed that the bill would be significantly changed to meet concerns of the attorneys and advocates' professions regarding their continued autonomy. It did not happen. One morning the bill was presented in its unchanged form to Cabinet. That afternoon it was introduced by the Minister. But that was the end of it. And on this point, where I do differ with certain of my colleagues, is that in two respects, I'm invited to read the long title in the preamble and to identify a single word which I disagree with. I don't. I think they're wonderful words. I think they're wonderful objectives, and I would depart from none of them. I have a simpler concern, that the price of the words is this lack of essential, thought-out, costed machinery in the Act which will achieve its noble objectives and without simultaneously resulting in too substantial a loss of the autonomy of the legal profession. And in that regard, I and others have never called for a regulation-free legal profession. You know, many people have, Robespierre said he would not rest until the last lawyer had been strangled with the bowels of the last priest. So we are in very bad company. Camus said we have to wear robes because otherwise people would see right through us. We have a terrible reputation exceeded only by politicians and by perhaps the oldest profession. But in this regard, though, the critical thing is how we address these aspects. And that is why, for me, it's not about more words. This comes from a lawyer who, as you hear from his voice, 2 days in the winter chill in Bloemfontein, uses too many words. But it's not about the words, it's about analysis. And that's where I say to my colleagues that I would sign here and now the Declaration of Principles, articulated again by my colleagues in AFT and Mthatha on the 23rd of June. I think they are entirely appropriate, noble and inspiring. My concern, though, is how do we achieve these things? And my colleagues here know this, that we struggle, and some of them are quite right. There's the fault, dear Caesar, lies not in the stars, but in thyself. It's in the profession. We have often not achieved things which we should have done. But I do not believe in the waving of a statutory wand. I do not believe in a couple of underemployed or retrenched university academics sitting in a council in Pretoria with an ill-thought-out regional substructure trying to deal with the delinquent practitioners from Messina to Simonstown. I've always espoused the belief that the regulation should happen differently. That just as the same way you can't be an unfranchised lifesaver on Clifton Beach, you have to belong to an appropriate organization which is vetted. If it does not meet criteria, essentially to train and to discipline you, you're out. My concern is this, that the delivery which we need, and which must be the heartbeat of transformation, will not be achieved more by drawing this up, in fact, exonerating many of us from involvement at lower levels into a statutory council with this wedding cake edifice of the regional bodies. But I've always believed that what you should do is register the organizations. And if they don't file audited returns, if they don't have proper training, if their discipline is slack, then you don't renew their registration. But be that as it may, these are quick thoughts, which is to explain to you how I support very strongly so much of what my colleague Ish Semenya said in articulating concerns and points of principle by my colleagues, and he speaks for them and I don't. But by my colleagues I know in relation to the bill. He does offer, in the enigmatic way in which I know and love in my colleague, these words of comfort that the bill will not be long in the form that it is. And I have hoped that through the intervention of his leadership and of many others seated at this table, that will be brought about. But I do have to say that debate cannot be stilled on the basis that I latterly heard, that they come to Parliament one and all, this is a bill which is going to Parliament, it's in Parliament. It does already have a certain locomotive force. And my main objection is, I say, it shouldn't be in Parliament in that form when undertakings were given but not kept. And secondly, as a bill, and here I believe I tap into many of the concerns of my colleagues, it should not be in the form that it is. I would leave the long title. I would leave the preamble. But there are fundamentals in it which require to be rectified. And lastly, where I do differ from my colleagues, and my friend and colleague Dali Mpofu, who has participated in some celebrated litigation with me in our mutual youth, said that what objection could there be, first as a rationale to the bill, that there are different laws throughout the country. I know that applies as regards the mosaic that has happened in the attorney's profession. But essentially, there's always been an Advocates Act in South Africa. It's a Verwoerdian model now, and I hold it up not as a model, not as something which should be retained in its terms, but I'm afraid to put it colloquially, by the rationale that there is some different law that governs me when I practice in Johannesburg or Cape Town or anywhere else. It's with respect not so. Secondly, the affordability rationale. Be suspicious. Be very suspicious. Because you will know that in appropriate circumstances, lawyers will approach certain litigants as if, in a spirit as if they are lactating litigants. They will, at times, extract a hard pound of flesh in commercial litigation, where they put their names and reputations on the line and don't sleep at night through preparation. The other truth is that many of us, and I think I can't say most of us, but many of us give up our time to act for nothing for certain litigants who can't afford us. And here I agree, and it's in the bill, but it already is so. It should only be enhanced by delivery. There should always be better and more effective pro bono and other services. So affordability, be careful. That is a political fig leaf. And I ask the rhetorical question, this council, how will it make things more affordable? The regional councils that we don't see. Thirdly, the question of representativity. Here is my one story of the evening. You've been treated to several by others. In 2008, I was part of a task group trying to rectify a situation that we're involving which, in terms of which the numbers of black women at the Cape Town bar was and is shamefully low. I phoned the Dean of Law at the University of Stellenbosch in 2008, and I said, how many people are in your LLB class? Because at the bar, one can't, with the best will in the world, recruit people from anywhere else than the fundamental legal qualification. His answer was 106. And I asked him, how many of these are South African black women? His answer was 5. Now, that gives you an indication, and that's the point I want to end on, of the societal problem that we face. There is no wand to be waved. Each of us around this table, I believe, in his own way, has tried to do what we can. And there were many who will all be criticized. We've dropped balls. We could have done more. But in the end, as the Bible says, physician, heal thyself. I do not believe in the waving of a statutory wand. I think this particular statutory wand has been lying around, and we're suffering from the fact that there's a certain sense suddenly of locomotive speed. So although I, as a private citizen, as it were, practitioner, holding no office, can do nothing more than put my faith and hope in my colleagues here, I would certainly hope that they make sure that that bill is analyzed and shown for what it is, and that we not be deferred by and deterred by the suggestion that when we rise up and criticize in certain respects, we are not patriotic or we're anti-democratic. It is a matter of thinking as a lawyer, of thinking as a member of civil society, and saying, how will this really enhance anything? And when it is said that the bill is the first step to transformation, I would hope that all my colleagues would say, no, it isn't actually. There have been many steps, faltering, failed, some successful, but you come back to that kind of social reality about which I am personally very, very concerned and conflicted. That when I turn to a university, and not a university with unprogressive admission policies, but a university where I ask, how many of this category of person could you give us? And the answer is 5%. We realize the enormity of the problem, and I hope that what we will do through your leadership, gentlemen, I'm afraid they're all gentlemen here tonight, but through your leadership, gentlemen, that we will enable the department. And I have no personal feud with the minister. The minister is a political head of the department, and he must take what comes with that. But that the department will understand that there are these big holes in the Act, and what they're seeking to do is to create a council where, in circumstances where the independence of the profession will not be enhanced and the price to be paid seems to me simply too dubious. Thank you for your patience.
We have, in fact, gone far beyond our time. But I will give an opportunity to all of you who are present, if you would like to raise something, take up an issue with any of the members of the panel, we can do so within the next 10 minutes, and that, unfortunately, will have to be closure. Yes? Would you just identify yourself?
The question I have to the panel generally is, it's well known that lawyers tend to interfere with everything. Why now do we need legislation to sort out this problem? Why can't the lawyers sort it out without the need for legislation? We find in the press have gone for, they've decided to go in-house. They've refused to accept any kind of government interference. Why are the lawyers not prepared to sort it out themselves and have to resort to the legislative route before we have any kind of attempt to try and sort it out, or any apparent attempt to sort it out by ourselves?
I don't think the initiative here came from the profession as far as the bill is concerned. I may be wrong. But is anybody would like to, Mr. Mpofu, would you like to say something about it? 1 minute, maximum.
You see, what the bill says, and I just want to clarify this, none of us are so naive as to think that just because it says ABC on the thing, then that's what's going to happen. That's what I've defined as the problematic statement that we have identified to make sure that that alignment happens. But why regulate anything, whether it's lawyers or whatever it is? The point of the matter is that the professions that we practice purportedly practice in the public interest. The government is there to protect the same public interest. And that really is what it's all about. Why do you regulate doctors? You should leave it to them to cut whenever they want. That's because it's in the public interest that certain restrictions have got to be put. Why do you regulate the mining companies? If you don't, you're going to have acid water and all sorts of things. And that taps into the public interest. Now, if you accept that our profession, generally speaking, I'm now talking about not just advocates or attorneys, but judges, anything to do with our profession, that essentially is a public service. It is a profession without which the whole entire democracy would simply collapse. If you didn't have the courts, if you didn't have everything that is embraced by generally what you call the profession. It's like the media. You know, you've made an example of the media. Media freedom, that is in the Constitution, is not the freedom of the journalists, of the people who have practiced that craft. It's the media it's the freedom of the citizen to get information. And that is the issue. Same here. The independence of the profession and all these nice things are not for us as lawyers. They are to ensure that the society itself gets this good, social good, called, or whatever it is that we churn out as the profession. And the reason that we regulate it, therefore, anyway, and I'm glad to hear that Jeremy says he agrees with the regulation, but the regulation should be in a different form. Fine, that's fine. That's what we're saying. We're saying we have 24 months to make sure that the regulation is in the form that we think it is. He might have a view of what it should look like, I might have another view, but we have a transitional council which will ensure that it
Dali, that's it.
Sorry, Dali, if I can just get
well, somebody, yes, all right.
Address. Isn't the issue not that there's an objection to regulations? We accept that there need to be regulations, but why does there need to be statute?
Yes. Well, that's an issue that is being debated. I mean, that is an issue which is whether the suggested reform would in fact be an improvement on what is there at the moment. But it's within the public domain, it is there, and it's got to be dealt with. Anybody else want to raise any points? I think that's it.
Thanks to you, Judge.